My name's Annette DeFavre, and I'd like to welcome you to the BC Library Association's Summer Conference Series. This session that we're going to do today is part of our 2020 virtual webinar series that we're calling The Conversation Continues. BCLA is privileged to be presenting the 2020 Summer Conference from the city of Vancouver, which is located on the unceded territories of the Coast Salish peoples, including the territories of the Musqueam, Squamish, and Tsleil-Waututh nations. When the BC Library Association realized that COVID-19 would mean the cancellation of our in-person conference, our annual conference, and with that cancellation, the loss of some truly amazing conference sessions, we asked presenters if they would share virtually some of the fantastic ideas and work that they had prepared for the in-person conference. So for BCLA, this was a great opportunity to partner with conference presenters and to contribute to the professional learning of the library community. So thank you to all the presenters who are contributing to the BC Library Summer Conference. So a few words about today's session. The session today is being recorded, and so what you need to know is that any comments or questions that you ask using the chat feature are captured in the recording. At the end of the presentation, during the Q&A portion of today's presentation, there'll be an opportunity to ask questions verbally. So at the end of the presentation, if you want to ask a question, you'll see on Zoom a raise hand feature. You can use the raise hand feature, and then we will unmute you so you can ask Dawn and Christina the questions that you might want to ask. I also would ask that for the duration of the presentation, if you could keep your video off, but feel free to turn it back on when you're asking questions. So now I'd like to welcome Christina de Castell and Dawn Taylor, who will be sharing their presentation titled Recent Canadian and International Copyright Developments, Impact on Libraries. Christina de Castell is the Chief Librarian at the Vancouver Public Library. She's fascinated by the way that technology is changing reading, learning, and libraries, and believes that each of us can advocate for library patrons and our values through our conversations and through our roles. Christina is Vice Chair of the Copyright Committee for the Canadian Federation of Library Associations and a member of the IFLA Copyright and Other Legal Matters Advisory Committee. And she has represented libraries at UN forums on copyright topics. Donald Taylor is the Copyright Officer for Simon Fraser University. He oversees interlibrary loans and the institutional repository at the SFU Library. Don is also the BCLA representative to the CFLA Copyright Committee. He recently completed research investigating the institutional and societal factors that contributed to the collapse of collective copyright licensing in the Canadian post-secondary sector. So welcome, Christina, welcome, Dawn. I'm going to turn it over to you now. Thank you for being here.
So thank you. So I'm Dawn Taylor, and I'm going to be the first one talking, and we can go to the next slide. Okay, so what I'm going to be talking about today, three separate areas. So the changes that are coming to Canada's Copyright Act because of the Canada-United States-Mexico trade agreement, update on the York University versus Access Copyright case, and also some information about fair dealing in documentary films from a very recent case at the Ontario Superior Court. So next slide. So CUSMA and international trade agreements. The Canada-US-Mexico trade agreement, or the new NAFTA, it's going to be introducing changes to Canada's Copyright Act, changes that our two most recent trade agreements did not. So the Canada-Europe Trade Agreement and the Trans-Pacific Partnership, they didn't require Canada to make changes to our Domestic Copyright Act, but CUSMA will make us make some changes. And it's kind of an interesting thing that in the recent last couple of decades, trade agreements seem to be the most frequently used way of harmonizing IP between countries rather than separate international IP treaties. And of course, CUSMA affects not just copyright, but patents and trade secrets, but we're just looking at copyright today. And for those of you who want to read the agreement, Chapter 20 of CUSMA is the intellectual property chapter. And on to the next slide. So the first area to look at is the technological protection measures and rights management information. So for those of you who aren't quite certain, TPMs or technological protection measures, those are used to prevent the copying of copyright protected works. An example would be you can't just copy and paste material from a DVD to your hard drive. And rights management information, or RMI, those are things like watermarks, for example. That will be rights management information. So CUSMA will actually, it allows for countries to exempt from criminal procedures libraries, archives, and museums if they break a TPM. So if Canada wanted to, they could introduce an exception for libraries to break TPMs for some purpose, okay? For example, for fair dealing, okay? And actually, during the recent 2018 Copyright Act review, various library associations asked for some sort of provision that would allow libraries, well, library staff, to circumvent a TPA for legitimate exceptions such as fair dealing. As well, CUSMA also will allow for libraries, archives, and museums, LAMs, and as well educational institutions to remove rights management information without being subject to criminal procedures and penalties if they wish to do so. So, you know, for whatever reason, we could remove a watermark. Okay, so again, that depends on the country in question introducing it into domestic legislation. But the agreement allows a country to do that. Next slide up. Another good thing coming out of the CUSMA negotiations is that Canada did not have to change our notice and notice regime. Okay? So notice and notice is the system Canada uses for the notification of an internet intermediary, something like an ISP or maybe a university. So when they're hosting copyright infringement material, so notice and notice requires the internet intermediary to forward on notices from copyright holders to the individual, alerting them that their account is being linked to infringing activity. And after that's been done, it is up to the rights holder and the account holder to sort it out between themselves. The internet intermediary is removed from the situation. So notice and notice is different from notice and takedown because under notice and notice, the internet intermediary only has to forward on a notice. They don't have to take down material, okay? In a notice and takedown situation, the intermediary actually would remove material. The US has a notice and takedown system. So you've heard of like the Digital Millennium Copyright Act and takedown notices. So that is what happens in the United States. Canada, according to Annex 20B to Section J of Chapter 20, it is clear that a country can maintain a notice and notice regime if they had one prior to the agreement coming into force. So next slide. So now we're on to the term extensions, which are sort of the area of CUSMA that people are more interested in because it tends to have a greater impact on how people perceive copyright. And they're the bigger changes. So CUSMA is going to extend the term of copyright protection for all works that we have, except for works created by the Crown. So government documents, those will stay at whatever rate the government wishes them to be at. So first of all, we're going to look at items that are protected on a basis other than the life of the author. So that's going to increase. It's going to go up to 75 years from the end of the first authorized publication of a work, or if it's not published within the first 25 years of creation, then protection is going to be 70 years from the end of the first year the item was created. Okay. And this is the copyright that we normally see in things like sound recordings. Okay, so the person who holds the copyright in the actual recording, the person who pressed the record button, you know, or home movies, which are called cinematographic works of a non-dramatic character. Anonymous works is another area that will be covered by these new term extensions. And as I said, it doesn't change Crown copyright. And these new term extensions have already been introduced into Parliament. You can see the name of the act there, an act to implement the trade agreement between Canada, the United States of America, and the United Mexican States. It's received royal assent, but it hasn't yet come into force. Okay, so all of these extensions in the next couple of months, you'll see them in the Copyright Act once it comes into force. So moving on to the next slide. Now we're looking at sort of the standard term of extensions that most people are used to, which are the ones that are works protected on the basis of the life of the author. So currently, that is the life of the author plus 50 years in Canada. It is going to go to a life of the author plus 70 years after their death. And it's going to apply to all those things that we think about, you know, books, musical works, artistic works, all of those. And this one, Canada has a time lag. So we have to implement it 2.5 years after our Bill C4 comes into force. So 2.5 years after we've implemented CUSMA, we then have to implement the new term extension for works protected on the basis of the life of the author. Okay. An important thing to note is that none of these term extensions are retroactive. So anything that is currently in the public domain stays in the public domain. Okay. The term extensions will only apply to works that are under copyright when the term extension comes into effect. So there's no need to worry about things falling out of the public domain back under copyright protection. That will not happen. Next slide. So there are some concerns about the life plus 70 term extension. So library associations expressed some concern about it. They were worried it would exacerbate the problem of orphan works. So that would make digitization projects more difficult. And it would also benefit a very small number of rights holders. I'm sure you're all aware that research shows that most rights holders don't obtain economic benefits from copyrighted works for more than a few years immediately after they're made available. So adding 20 years of copyright protection is economically benefiting a small number of rights holders. And one other thing that libraries reminded Parliament about was that often the rights to publish works are held by a publisher and not the author. So people have suggested ways to mitigate this term extension. So libraries and others in the most recent Copyright Act review did propose a couple of different things. One of them is a registration system. So we'd implement a registration system that makes a right holder register the work to get that extra 20 years. A couple of potential problems is that no one else does this, and maybe it's not even allowed under CUSMA because of the language of the agreement. Another possible mitigation measure would be rights reversion. So that would mean that in the Copyright Act, there'd be a provision that would allow a creator who would transfer their rights to a third party to regain their copyright after a fixed period of time. So for example, say after 25 years after they transfer their copyright, they'd be given a window of time to file a notice that they're going to get their copyright back. And during the 2018 Copyright Act review, both libraries and many creator groups promoted this. And in fact, it was included in the final recommendations from the ISED committee. So they actually favored a rights reversion provision. And just for your information, the US actually has a rights reversion provision in their Copyright Act for musical works. So we're going to move on to the next slide. Just brief review of what happened with York University versus Access Copyright. If you remember in 2017, there was a decision from the federal court where Access Copyright basically won. The court found that copyright board tariffs are mandatory and that York's fair dealing guidelines were not fair. Okay, York appealed that to the Federal Court of Appeal. And in April of 2020, the Federal Court of Appeal ruled. Next slide. So in the on appeal, the Federal Court of Appeal ruled that Copyright Board tariffs are not mandatory. That is, a user has to agree to be bound by a tariff. They're not automatic. But the court still found that York's fair dealing guidelines weren't fair, and neither side has yet decided to appeal. So it was kind of it was a draw. One side, each of them won one part of the case of the appeal. Next slide. So on the subject of tariffs, a bit of history here. In the early 2010s, Access Copyright changed from negotiating licenses with educational institutions to filing tariffs with the Copyright Board. And Access Copyright was under the impression that tariffs were binding. If Simon Fraser University infringed the copyright in a single item in Access Copyright's repertoire, that meant that the tariff was binding on the university, and SFU would have to pay the full amount of the tariff to Access Copyright. Okay. The Federal Court of Appeal said, no, that's not the case. Acts of infringement don't turn infringers into licensees. Okay. And so infringers are subject to an action for infringement and liability to damages, but only at the instance of the copyright owner, which meant the copyright owner has to come and sue them. Next slide. So the takeaways from that decision is that tariffs aren't mandatory, they're optional. That tariffs are a way to, as a limit on rights holders to ensure they don't abuse licensees who sign on to tariffs, and that a collective society can collect an entire tariff payment from a non-licensee as the penalty for a single instance of copyright infringement. And lastly, it's the right holder who has to sue for copyright infringement. Collective societies can't do it under the guise of a mandatory tariff. And next slide. Just very briefly, as I said, the Federal Court of Appeal ruled that York University's fair dealing guidelines weren't fair. And mostly it turned on the question of who is the user. York University didn't talk about the student really at all, and the student using it for fair dealing. So the judge was like, well, hey, all I can do is look at it from the perspective of the university then, and for their perspective, institutionally, York's guidelines weren't fair, and really it turned on the issue of institutional safeguards. Federal Court of Appeal said, just like the federal court, that York lacked institutional safeguards to make sure that their guidelines weren't easily abused by staff and faculty. And also, again, they weren't able to show that the students' use of the things were fair dealing because they just made no attempt to show that. And moving on to the next slide. So fair dealing takeaways, just things to remember, very important. This was a judgment on York's guidelines as they existed in 2013. It's not a judgment on anybody else's guidelines. It was specific to York University and their circumstances in 2013, not their circumstances in 2019 or 2017. Every institution is different, and their policies and procedures may well be fair. And lastly, let's remember, this wasn't a copyright infringement ruling. So no rights holder sued York for copyright infringement. Okay, it was Access Copyright saying that we think you've infringed copyright, therefore you got to pay us a tariff. Okay. So again, it doesn't change anyone's guidelines. It doesn't suddenly mean that, you know, Simon Fraser University's copyright guidelines are suddenly unfair. York's were unfair in 2013. And on to the last slide. Just something I thought that, you know, people would be interested in, because oftentimes the assumption is that fair dealing doesn't apply to movies at all. Okay, but very, very recently, just this past month, there was a fair dealing, a copyright ruling out of the Superior Court of Ontario, and they ruled that the use of film clips from the movie The Room in a documentary titled A Room Full of Spoons was fair dealing. I don't know if you know this, but there was this movie called The Room is considered to be one of the worst films ever made. And therefore, it's become a cult film. And it was actually Tommy Wiseau was the director of The Room. And it's become a cult film now. Like, it's so bad that lots of people watch it. And So this documentary, Room Full of Spoons, they tried to get permission to use clips of the room. They never heard back. Their requests were rejected. So they went, we think it's fair dealing. In turn, they got sued then by the creators of The Room. Went to the Ontario Superior Court, and after a very thorough analysis, the court ruled that no, fair dealing does apply to documentary films. Criticism, review, and news reporting certainly apply. So this is an important ruling because films have always been like so risk averse. Everything had to be licensed. So to see that the courts will accept a defense of fair dealing in documentary films is important, and something we'll want to take under advisement when assisting film students and others with determining the risks of including copyright protected works in their films. And that's it for me, and it's over to Christina.
Thank you, Don. And just to let everyone know, we're going to take all our questions at the end. So I have a number of slides to go through, and we're planning to leave lots of time for questions. So don't worry that you won't have that chance to ask. So I'm going to talk about a few things, not about what has changed in legislation or in law, but how we're working within the legislation and the law to operate. And so what it is that gives meaning to the rights and the exceptions that we have in copyright legislation. So I'll cover 4 areas that have had a lot going on in the past year. One of those is the Marrakesh Treaty and its implementation guide. Another is ebook licensing, and then controlled digital lending, and more recently, the National Emergency Library and online Storytimes. So a couple of these are very particular to the COVID-19 environment, and the others are areas that are of continual interest for many libraries in Canada. So starting with the Marrakesh Treaty, for those of you who are perhaps less familiar with this area of work, it's very important for work around accessibility. So the Marrakesh Treaty is to facilitate access to published works for people who are blind, visually impaired, or otherwise print disabled. And it sets up in copyright what we are actually always dealing with in libraries is the limitations and exceptions to copyright. So copyright is the right of the creator or the right of the rights holder, and we're working within exceptions. So the Marrakesh Treaty creates a set of limitations and exceptions that allow organizations to reproduce and distribute. And in particular, what's important about the Marrakesh Treaty is that it's about the cross-border exchange of works, so that a library or an organization serving the print disabled doesn't need to create its own accessible version of a work if it's been produced in another country. And this is important because less than 7% of published books are made available globally in accessible formats. So the Marrakesh Treaty was signed back or adopted back in 2013 and came into force in 2016. It needed a certain number of signatories at WIPO before it came into force. And Canada committed within that first group of signatories. And there are now 67 countries or states that are contracting parties. And so I've given you a list of some of the more recent ones that have signed on. Libraries have been a very important part of the work on the Marrakesh Treaty from the outset, and so it is a big focus for IFLA's Copyright and Other Legal Matters Committee and has been for many, many years. So what has happened in the past year is that through IFLA and through the CFLA, the Canadian Federation of Library Associations, work has been going on to communicate to libraries what it means to implement the Marrakesh Treaty. So this guide was just published in a Canadian version by CFLA. The original international version was created by IFLA with the World Blind Union, EIFL, which is electronic information, and they do a lot of work in development, with Carl and with the University of Toronto. So I'd like to acknowledge those who worked on it in Canada: Mélanie Dumas, Victoria Owen, Mark Schwartz, and Christina Winter. And the great thing about this Marrakesh Treaty guide is how easy it is to understand. It's set up as an FAQ, and it really takes you through what the role of the Marrakesh Treaty is, and then how you work within it as a library. And every library in Canada that is nonprofit is eligible to use this treaty. And what that means is that when you create an accessible work, you're allowed to share it across borders. And when you need an accessible work that's available elsewhere, they are allowed to send it to you. And that is important. So the Marrakesh Treaty implementation in Canada is something that had to be brought into our copyright legislation and has been. So this guide covers all of the elements. So your permissions around bypassing technological protection measures, how you deal with situations where there's a license in play, and it is specifically looking at our implementation in Canada, and what steps you can take to improve access to works and getting material from other libraries. So there are international organizations that gather together those metadata records and make it possible for you to discover whether a work is available in accessible format already. So if you work in accessible services, you're serving people who are print disabled, it's really important to be aware of the Marrakesh Treaty and to take a look at this guide and to understand how you can get access to formats. And the bodies that in Canada, the library bodies that are working closely in this area, of course, are CELA and NELS. So both of those organizations are organizations where we can work together to facilitate access to accessible works. And you can direct some questions to them if you're wondering about this as well. But do take a look at this guide if this is an area of focus for you. So another area that's been a big part of library world news for quite a long time and continues to be is anything around ebook licensing and e-content licensing. So we're continuing to have issues and I'm speaking in this context about public libraries, issues related to cost, issues related to timed and metered licenses, and particularly a shift towards timed licenses in the past year or so. And then really significant issues arising around availability of content. 10 years ago, it was very hard to get access to Canadian content because US rights holders were moving faster than Canadian rights holders, and Canadian publishers weren't aware of the importance of libraries and digital rights. But now the issue is that Audible and Amazon are buying exclusive rights to content. And so in some cases, what's happening here is Amazon or Audible, they go to the Canadian publishing company and say, we're interested in making an audiobook of your Canadian work. And we will cover the costs and we will sell this work when it's created. And this sounds like a fantastic deal to publishers. However, when Audible creates the work, it's exclusive. And when something is exclusive to Audible, libraries can't buy it. So it's a huge problem if a Canadian publisher unwittingly signs over exclusive rights to Audible for Canadian content. And in some cases, we've been able to raise awareness among Canadian publishers of this problem. And we have an example of a publisher who was able to retain the rights to the masters of the audio works and produce a version for libraries. So that's not always going to be possible, but when publishers understand what the situation is and the impact that has on libraries, and they do in Canada really care about access in libraries among Canadian publishers generally, then there are ways around this problem. So this is an opportunity for anyone working directly and communicating with Canadian independent publishers in Canada to let them know that there is an issue here and that you can negotiate in this situation to ensure that libraries will be able to provide audio access. It's really important that we have this equity of access, that availability is there for Canadian content. And so what we've seen over the past year is right around June, July of last year, quite a significant shift away from perpetual licensing and towards shorter terms. And in some cases, this came with lower prices, but it creates a real problem for a library as a perpetual source or a permanent source of content. And it also has impacts on our ability to give access to mid-list and less popular content in the longer term, because an item that doesn't circulate very much is not going to be worth buying under a 2-year license, Whereas if it had been, say, the 26 circulation model that HarperCollins uses, that could potentially be around for a very long time. So in this past year, all of the big multinational publishers have started moving in this direction. So we saw Penguin Random House do this a little bit longer ago, and then Hachette announced their move to 2-year licensing last year at this time. Simon & Schuster did the same. Blackstone implemented a 90-day embargo, so libraries can't purchase Blackstone audio content for the first 90 days that it's available. And Macmillan announced that starting in November, they would also only allow one license for the first 8 weeks. So libraries could buy one copy, which is just a way of generating a really long waiting list. So that's what was happening a year ago. Now, in the past couple of months, we've seen a bit of shifting to recognize the environment around COVID. So Penguin Random House has started to provide a discount on 1-year licenses. Macmillan lifted their embargo on the first 8 weeks. So there is a recognition among a lot of publishers and content providers that this is a unique situation and that we are dealing with a huge need for digital content, and print is not going to fit that bill. And certainly there was a period of time when even if you wanted to order a print book on Amazon, it had a really long wait. So we are working in a different space. HarperCollins, House of Anansi, and Sourcebooks also offered temporary discounts in the past couple of months. We've seen some of the more multi-user licensed, annual licensed content repositories expanding their user access. So where they might have been quite restrictive before and said to libraries, only your residents can have access to this content, we're seeing more willingness to give access to anyone who's a card holder of the library. And that is a slightly broader understanding of the concept of your licensed users. We've seen Gale and World Book provide free access to their content, and Taylor Francis free access to their COVID resources specifically. So it is good to see that there's recognition of a unique need. I hope that we'll see some of this continue coming out of this crisis, but of course at this point I'm not really optimistic about that. We have the CULC, the Canadian Urban Libraries Council e-content group, working very hard on advocacy in all of these areas around fair licensing and fair pricing for libraries to ensure that equity of access among library users. Another hot topic in the library world these days for both public and academic libraries is controlled digital lending. And so this is a project from the Internet Archive, and the other way you might be aware of it is the Internet Archive's Open Library. So the Open Library is the implementation of controlled digital lending. What controlled digital lending is the belief that it is appropriate for an organization or a library to digitize a legally acquired print copy and to make it available on the basis of only one copy being loaned at a time. So if you own one copy of the book in print, you can lend one copy of the digital version. If you own, but you can't lend the print book at the same time. So you can take a print book and digitize it, but if you only bought one legally, then you can only lend one legally. And if you happen to own 30 print copies, then you could create 30 digital copies and loan those. So it's important in the case of controlled digital lending that that loaned digitized copy is secured, and generally also that the print copy is withdrawn from circulation. You don't want to have a situation where the print copy and the digital copy are circulating at the same time. So this is particularly valuable because it addresses the problem of older books that are still in copyright, but they're not available digitally. So there aren't licenses available for them. They haven't been digitized by the publisher. There are a lot of collections held in libraries that are in this situation. There's a very robust white paper on controlled digital lending in the context of US legislation available on the controlleddigitallending.org site, and I've got the URL there in the corner. And the United States uses fair use rather than fair dealing. So in Canada, we need to think about this a bit differently. The CFLA committee has been working on a risk framework, and there's a webinar coming up with Carl towards the end of June where we will talk specifically about controlled digital lending in more detail. So we have a number of Canadian libraries that are looking at controlled digital lending or participating in the open library, and I've listed a few of them here. So what generally is being considered as within the scope of fair dealing in Canada, or more safely within the scope, the lower risk, is what we can think of as older copyrighted material. And Hamilton Public Library had a legal opinion on the topic of controlled digital lending under fair dealing, with some recommendations of what would be safe for a library in Canada, or relatively safe for a library in Canada, to digitize and make available through the controlled digital lending process and through the open library. So the actual act of doing this has so far, the organizations that have it in place are the University of Alberta and Trent University. There are others that are thinking about projects. So the University of Alberta, generally it's historical and educational collections that they've digitized. So it's more of a special collections category. It is work that is within copyright, but it's not popular commercial material. And that's what this idea of risk analysis for controlled digital lending, that's what's really important, is to be thinking about what your comfort level is on level of risk. And so far, the other Hamilton and Milton are participating in open library with content they already have in their collections, but they have not put digitized content out there. So Hamilton is looking at older copyright material, based on the legal opinion that they've received. And then Trent was a little bit different because Trent University donated their books to the Internet Archive. So we have been in the CFLA committee working on controlled digital lending as preparation for helping libraries understand how they might participate. However, just a little while ago with COVID, the landscape has changed. And the Internet Archive launched the National Emergency Library in March of 2020, and it is making everything that was in the open library available with multiple copies borrowed simultaneously. So it's removed the element of control of number of copies from the concept of controlled digital lending. There's still the digital locks there, but people can borrow more than one person can borrow a copy at a time. There are no wait lists. They're 14-day loans. The books that are being made available are not books published in the past 5 years. So there is it's debatable how much of a commercial market there is for these books. The intention that the Internet Archive is communicating is that they are for educational purposes. And they had provided a webinar recently where they communicated that most of the use has actually been for 30 minutes or less. So this isn't a resource that people are going into to read Harry Potter. It's a resource that people do appear to be using for educational purposes. However, 4 major publishers filed a lawsuit on June 1st against the National Emergency Library and Internet Archive. And this was building for quite a period of time. So you can see a little bit of the press, which started in March as soon as the National Emergency Library was made available. There's not a really good understanding. There already wasn't a really good understanding of how the open library and controlled digital lending worked. And this removal of the wait lists and the control aspect of the own to loan ratio has really created a new challenge. So for the moment, we are pausing some of the work of the CFLA committee, and we'll see how this all plays out. It's a challenging time to start putting out guidance for libraries in Canada on participating in the open library, just given what a hot topic this is. And we've got a lot, we all have a lot else going on right now. So we are interested to see how this situation plays out, because the approach of the National Emergency Library is fairly different from controlled digital lending. And yet that access to content in this COVID environment, when we have libraries closed, is also very different. So we don't have access to the physical works, and they are all being held and untouched in our physical libraries. So there's a lot to think about and understand, and that you can read about around this topic right now. And then finally, I would like to briefly talk about online story times. So we've made CFLA guidance available through May 8th publication. It's available on the CFLA website. And there are a few elements here. So when a public library provides online story time to children, they are generally working within an early literacy purpose. And the act of story time having an early literacy purpose is critical to applying a fair dealing education purpose and not requiring permission from a publisher or a rights holder. So there's two different ways that you can approach doing an online story time as a library. One of those ways is to seek permission from the publisher or from the rights holder. And in Canada, the Association of Canadian Publishers, pardon the typo there, and Access Copyright have put up a statement of permission and what publishers are participating. And so you can check that Read Aloud Canada resource to see what publishers are saying they're granting permission for libraries to do online story time and what their terms are. However, when you do story time for an early literacy purpose, you don't need to get permission. You don't need to have a license. You can do this story time within the terms of fair dealing. And this is as long as it has an educational purpose, so an early literacy purpose to that story time, which I would think that most of us do our story times with that purpose, but it can't just be reading the book. We need to add those extra early literacy aspects, that language play, those questions, the engagement of the child needs to be part of this process. When you choose to use fair dealing as the approach to making an online story time available, some good practices are to acknowledge the author, illustrator, and publisher, to use a live stream if possible rather than a recording. And if you are recording the work, then to limit the amount of time that recording is available. And also to provide contact information so that if the author or publisher wants to get in touch with you to ask you to take that recording down, that they can. So whether you choose to use permission or to use the fair dealing exception to deliver an online story time, what you need to understand is that you are making a choice about the level of risk that your library is prepared to take on. And these steps of acknowledging the author and using a live stream or limiting the time the recording is available, these are all steps in your risk mitigation strategy. So you have a choice about how you approach it, and if you're really uncomfortable with the level of risk, then go with permission, go with the read aloud list of publishers, or look on the publisher's website to find out if they're giving permission for the use of their works and what their terms are. But if you feel comfortable with taking the risks involved in fair dealing as an educational purpose, then you don't need to go through that process. You can follow these good practices that are listed here. So I will now close there and we will move to questions. And so Dawn, I will hand it over to you for managing the questions. And for those of you who would like to ask a question, you can find your name on your participant list and put up your hand, and then we will unmute you. I see we actually have questions in the chat box. So Dawn, I'll start off and read the one for you, and then you can read for the one for me after. So it came in privately. So what would adequate institutional guidelines look like? I think we're coming back to York there.
Yes. So very, very first statement. This is not legal advice by any stretch of the imagination because I am not a lawyer. The guidelines are going to be different for every institution. You know, I mean, there is guidance for at the college and institute level from colleges and institutes. ICANN from that level, and also at the university level from Universities Canada. And, you know, it really, the York situation was they had no institutional safeguards. Okay, so they had these guidelines and they had no way of, for want of a better word, enforcing them. You know, they didn't even monitor to make sure they were followed. So I think the big takeaway from the York case is that you do need to have some way of monitoring what is happening at your institution with regards to copyright. And I don't know, at least from my personal perspective, if we look back at the original federal court ruling, they keyed in on the difference between scholarly works and creative works. Like they certainly saw a short story as being something different than a chapter from lecture notes in computer science. Okay, so, and I think that's as well something you have to take into account. And of course, which a fair dealing analysis would tell you to take into account, which is that, you know, some works are different than other works. They might both be a chapter from a book, but a short story, you know, is not the same as a chapter on, you know, environmental protection of, you know, and emissions guidelines. Okay, one is a scholarly work, one is something somebody wrote as a creative work to earn a living. So, you know, you have to take those into consideration as well. So I think it's that, and also, you know, some type of monitoring system. Not that you're looking at what everyone's doing, but that you have some way of saying that, yes, we do check, we do, you know, ensure that people are following the guidelines.
Thanks, Don. So I've got a next question that I think you can't see, which was, would text, so this is related to controlled digital lending. Would textbooks that are not available digitally be covered by controlled digital lending? And what if it's available digitally but not to libraries, for example, through VitalSource, which sells directly to students? So the thing about controlled digital lending is it's all very much a space of risk evaluation. And right now, there's a lawsuit going on in the States around the whole thing, and it's untested, it's unevaluated, and lawyers' opinions are different. So if a library chooses to digitize something and it's not available digitally, so it's a textbook and it's not available digitally, well, there's a good argument for why you would want to make it available digitally and why you would need to. And if you were doing it to make it available for an accessible format, that would be another story entirely. That's a different part of the copyright legislation. So if it's commercially available or available for sale, then what you're wanting to think about is that fair dealing analysis that I was talking about for online Storytimes. And so you need to think about how broadly available it is. And that's what controlled digital lending is saying. We're only making one copy available at a time. And what's the market for this, and how is this product damaging that market, and make that argument or think through that argument. So controlled digital lending can apply to anything, but the level of risk that you undertake as an institution varies depending on what the thing is. So a textbook not available digitally that was published 30 years ago is quite different from a textbook not available digitally that was published a month ago. And those are wildly different levels of risk or levels of appropriateness for a lot of institutions for controlled digital lending. Same thing if it's available digitally, but not to libraries. If libraries can't buy it, then you've got an argument of lack of availability. You didn't have an alternative, but you would have to have purchased the item in print before you digitized it, because the legal acquisition is vital to the concept of controlled digital lending. However, I do need to note, as Don did, that this isn't legal advice, and in fact, we have not completed an analysis of fair dealing risks in Canada, though Hamilton Public Library has obtained a legal opinion for what they are thinking about using, but that's a particular context. And then another one for Don in the chat.
Yes, so the question is, how do you balance safeguards and enforcement with academic freedom of faculty? So yes, I mean, faculty have academic freedom, and it's certainly very important. And that is one area I think that in the past, access copyright, and maybe even the federal court back in 2017 didn't really properly understand. But you can certainly, you can balance them. Like you can have like I said, monitoring doesn't mean that you're in there all the time looking at what faculty are doing. For example, you could have a system like some institutions do where if they're using copyright protected works, it actually just goes through a central clearing point. Like that's harder to do at a larger institution, but at smaller institutions, you can have if you want to post, document X in your learning management system, you just, send it to the copyright office, they vet it and go, yep, that's fine, or no, we think you need to get clearance, and send it back and it goes into the LMS. So, or you can have you can just have surveys. You can just ask people, what is it that you put in the LMS this year? So, so it can certainly be done, but yes, I mean, I don't think you would want to try to implement a system where you told all your instructors that, the university is going to go in and look at all your courses that are in the learning management system and audit them for copyright infringement. That would raise all kinds of academic freedom flags, because you're giving people access to material that has nothing to do with copyright, and you're just looking at, an entire course and what they're teaching. So I hope I answered that question. Let me know if there's a follow-up to it.
This is a super long question.
That's a super long. I'm going to leave that for Christina.
So the interaction between authors and publishers is very interesting. And I would say that a lot of authors are commercial trade authors are not in a position of power in negotiations. And what that means is that as they are trying to negotiate their contracts, they're having to balance quite a number of things that they're not going to be happy with in the course of their agreement, and decide which ones are most important to them. So we need authors on our side, but the most effective authors to have on our side are the ones that have the highest profiles, because they're the ones who actually have some power in a negotiation. For most authors, even communicating to them what the problem is worth doing so they understand, but it won't change the situation we're in as libraries, because ultimately when they get an offer from Penguin Random House, they're going to be really excited, and they're not going to be focused on whether the library has access to their book, and they're going to have much greater concerns about what their royalties are and whether they're getting paid and whether they're giving away rights for other formats, for movies, for games, for comic books, for merchandise. So they've got so much that they have to negotiate. And so as I think that the concept of a boilerplate license between authors and publishers could be helpful for us in the realm of independent Canadian publishers, but it's not likely to help where we have the most problems, which is with the multinationals. We do and need to continue to try to get those big author organizations on side, the Writers Union, the International Authors Forum, Society of Authors, all of those bigger bodies. They can help to raise awareness, but ultimately it is the publishers that we have to keep working on, because it is the publishers who have the power in the discussion and negotiation. So in my opinion, it does need to be publishers where we keep working, and publishers can't ensure worldwide access don't ensure worldwide access in their agreement, because publishers are multinational, not international. So very few trade publishers are actually buying rights to worldwide. So I'm going to give you the example of, my husband's a trade published author, and his books are, sometimes the rights are bought worldwide and then sold, and other times the rights are bought bought worldwide and they publish worldwide. But then you have ones where they bought the rights only to publish in the UK and they're selling the rights to others to publish in Russia or to publish in France or to publish in Spain. So there isn't this concept of worldwide access to a book. That's not really how publishers work. There are very, very few international, I can't actually think of any international publishing companies in the commercial trade environment. They're all multinationals. So when I worked at IFLA for a year, we tried to deal with this with the International Publishing Association. And this is when it really became clear how separately every publisher works from country to country. So the UK Penguin Random House works more closely with the Australia Penguin Random House, and the US Penguin Random House works more closely with the Canadian one, but they don't talk to each other. And so we actually see very different deals coming out for libraries coming out of US and Canada versus UK and Australia. And that is very frustrating because we are used to working in libraries, working together across borders. And we're very supportive of that approach, but that isn't the case. So addressing ebook content that's only available in certain countries by certain publishers requires us to tackle the rights holders in each of our individual countries and convince them individually. And it's really too bad that we can't do it through international associations, but so we keep trying to spread that message through the international associations, but ultimately it is work that needs to be done in each individual country. There's great research from Rebecca Giblin out of Monash University in Australia about this, about the availability and the pricing and licensing differences from one country to another. And so she worked with the IFLA e-lending group and looked at availability of a certain body of content in the US, Canada, UK, and Australia, and compared those different availability and pricing and licensing models. So take a look at that if you're interested in understanding the differences. But it is because of the structure of publishing, which is national. And we're just coming up to 11 o'clock, and I'm not seeing any hands up. Don, do you see any questions we've missed? No? Okay.
Nope.
So thank you, everyone. Please do feel free to reach out to us directly if you have questions that you didn't get to today. I know we're both easy to find out in the internet world, and I will turn it back over to you, Annette.
Great. Thank you, Christina. Thank you, Dawn. It's BCLA's pleasure to host you today, and we welcome your contribution to our collective learning. For those of you that would like to rewatch the session, if you'd like to recommend it to someone else, or if you're interested in the other sessions that are part of the BCLA Summer Conference, please visit the BCLA website. And that website's at www.bclaconnect.ca, and you'll find all the information you need there. So thanks again for your contribution today. It's a pleasure to see you both, if just virtually, and thank you to all of you who have attended. Best of luck going forward. Thank you all.